councils, functions of the state bar councils are in 6, are to admit persons as advocates on its roll, while 6B stipulates that the state bar councils are to prepare and maintain such roll. 24(1)(e), read with 28(2)(d) of the Act, empower the state bar councils to prescribe conditions subject to which a person may be admitted as an advocate on any such roll. Therefore, a plain reading of the above mentioned provisions indicates that the functions of the State Bar Council relate to maintenance of rolls and admission of persons as advocates on its rolls, prescribe conditions as to what documents they will produce, etc. In stark contrast to these functions given to the State Bar Council, the rule-making power of the Bar Council of India under 49(1)(a)(g) of the Act clearly relates to prescribing rules to specify which class or category of persons, will not mark these important words, would be entitled to be enrolled as advocates. The scope of the Bar Council of India's power under the Act is therefore in relation to determining the entitlement to be enrolled as advocates. Then, we see the difference in words and phrases between enrolled and entitled. In this context, reference needs to be made to the meaning of the terms conditions, enroll, and entitled to understand the true import of these provisions. Ramanatha Iyer's advanced law lexicon, the above mentioned terms are defined in the following manner. Condition, thing on whose fulfillment another thing or act is made to depend. Condition is a restraint or bridle annexed and joined to a thing, so that by the non-performance of not doing the party, the condition shall receive prejudice and lose, it should be LOSC, by the performance and doing of the same. Enrollment. Enrollment in English law is the registering or entering on the rolls of Chancery, King's Bench, Common Pleas or Exchequer, or the Clerk of the Peace in the record of the quarter sessions of any lawful act. Enroll, enlist, register, record. Enroll is generally applied to the act of inserting names in an orderly manner into any book. Enlist is a species of enrolling applicable only to the military. Enrollment is an act of authority. Underlying question, to enroll and register both imply writing down in a book, but the former is a less formal act than the latter. Entitled, to give a claim, right or title. This is what is entitled, which is prescribed in 49(1)(a)(g). To give a right to demand or receive, to furnish with ground for claiming. The interpretation is in each case a question of construction and no definite rule can be laid down. Entitled to, expression entitled to occurring in 38 of the Act would mean that a person has acquired certain characteristics to enable him to be a member of any of the bodies of the university. In the case of elections, the entitlement would be only mature on the person being duly elected. Reading the above mentioned definition with the functions entrusted with the state bar councils and the powers vested in the Bar Council of India, the spheres in which both these bodies function become clear. The State Bar Council being tasked with the function of enrolling persons as advocates would mean the act of inserting names in an orderly manner in the register maintained by the State Bar Council, and any condition to be specified by the State Bar Council would be a thing which needs to be positively fulfilled in order for the State Bar Council to then proceed to admit the person on the rolls. This could mean either conditions which are in the nature of forms to be filled, documents to be provided, or in relation to the prescription that a person must not be in employment at the time of seeking enrollment, on fulfillment of which the State Bar Council would undertake the act of inserting the name into a register. Whereas, in the case of Bar Council of India, Section 49(1)(a)(g) of the Advocates Act, this is expanded again, empowers the Bar Council to prescribe rules that would prescribe a class or category of persons who are entitled to be enrolled. Meaning of entitled as set out above would indicate the Bar Council of India could prescribe such condition which could give the right or claim to a person to be enrolled as an advocate. This therefore implies a power for the Bar Council of India, which exists in consonance with the powers and functions of the State Bar Council and could be exercised to prescribe conditions that would have to be satisfied in order for a person to obtain the very right to be enrolled. I have developed, doctrine of incidental ancillary a little later, on how ultra-virus is to be understood in the context when a power is conferred. It is encompassing, all the incidental ancillary aspects of for the meaningful exercise of that power. Sudhir Court failed to consider that subsection 1 of 24 is subject to the other provisions of the Act and the rules. Your Lordship sees 24, the opening parts. The traditional lawmaking can either have a non-obstante or a subject to 24. And what is the meaning of subject to the provisions of the Act? That means, my lord, this will cede to other provisions of the Act, like, my lord, 49, and rules made therein, subject to the provisions of the Act. It is not notwithstanding, my lord, anything contained. Subject to, my lord, we have given case law on what is subject to. Kindly come back, my lord, to the note, para 48. Having considered the theoretical underpinnings of the functions vested in the State Bar Council and the Bar Council of India, it is then apposite to refer to some of the major reasons why Sudhir for holding the training and examination cannot be provided at a pre-enrollment stage by the Bar Council. In concise terms, the reasoning reads, 24(1)(d) and 28(2)(b) of the Advocates Act empowered the State Bar Councils to provide for pre-enrollment training and examination. The power to frame such rule was subject to approval of the Bar Council of India. This specific power entrusted to the State Bar Council has been repealed through the amendment of Act of 1973. Citing, they also give a reason that the same was not required in view of the 3-year law courses in the country. When such a power was vested in a body and thereafter repealed, the Bar Council of India cannot claim to have had the power to hold. This is what Sudhir said.
Yes.
The findings of this honorable court based on a reading of the provisions of the Act that existed and the amendments made therefore required to be addressed on a wholesale reading of the Advocates Act. Firstly, 24(1)(d) of the Act, which prior to the amendment of 1973 prescribed a pre-enrollment training and examination at the behest of the State Bar Councils, must be read with the opening words of the said subsection itself. 24(1), the Act opens with the words subject to the provisions of the Act and rules made thereunder, thereby making the conditions under 24(1) and its subclauses directly subject to the rules framed under the Act. As held by this court in Ashok Leyland, there are a number of other cases. Term subject to means that it is subordinate or subservient or to be governed or affected by whatever is prescribed. That the provisions under 24(1) of the Act are subject to the other provisions of the Act, and in particular the rulemaking power of the Act under 49 of the Act, is clear from a reading of the very opening words, and this is then fortified by the opinion of this court in Satish Kumar Sharma versus Bar Council. This court categorically held that enrollment under 24 of the Act is subject to the rules framed by the Bar Council of India under 49 of the Act, even if no rules were framed under 24(1)(e) or 28(2)(b) of the Act. Para 9 of this judgment will not be significant, that 49A will have to be still followed, 49(1), notwithstanding 24(1)(e) and 28(2)(b). Secondly, in the light of submissions made in the heading immediately preceding, the present heading, we have one comment on this deletion of 24(1)(d). Actually, it made sense deleting nowadays. There are a number of state bar councils. Each could have had a different pattern of examination.
So the uniformity would not. It's defeated. It's like having the problem which QT is trying to cure, which is different board exam with different levels of difficulty.
Though the ostensible reason given as noticed in Sudhir, in fairness to Sudhir, I have to point out, original 2-year law degree courses became 3-year law degree courses. So they said, why now have a training again or an exam again? But
possibly even underlying pinning could be the how it would work out.
Kindly imagine, Mr. Prabhakaran will have one set of rules in his bar council. The other states will have their own set of rules.
Mr. Mishra and Mr. Prabhakaran will have the same set of rules.
That's true. So
they have had meeting of mind on many issues.
Yes, and that Milord is taken care of if this power is left to the Bar Council of India.
The PEX body.
PEX body. They prescribe the power, Milord, all of them implement it, and there is one uniform. Otherwise, Milord, it would have been chaotic under 24(1)(d). Though it got deleted for some other reason, there is strong logic behind it, Milord. We will, Milord, in the 3-pager mention this uniformity, Milord, because this, while revising it. Secondly, para 50, in the light of the submissions made in the headings immediately preceding the present heading, court's rejection of the nexus between 24(1) and 49 based on the fact that Bar Council of India had no role to play in imposing pre-enrollment conditions does not hold water. The Bar Council of India is clearly entrusted with the rule-making power to prescribe those persons that are entitled to be enrolled. it is humbly submitted that 24(1) of the Act and its opening words would make the section and the conditions leading up to attaining the right to be enrolled subject to the rule-making power under 49 of the Act. Thirdly, it is submitted that even assuming that the Act prior to the amendment of 1973 had empowered the State Bar Council to prescribe training and examination, it does not take away the power that is vested in the Bar Council of India under 49 of the Act. Humbly submitted that the legislature is not expected to have any superfluous provision that the Lordship will not construe any provision as otiose or nugatory, that specifically empower the Bar Council of India with this specific action regarding pre-enrollment training and examination with the purport of 49. Though, my lord, the words used are classes or category of person entitled to be enrolled. While construing that, my lord, your Lordship will grant it those incidental and
I'm saying classes and category will include the prerequisites to be so enrolled.
prerequisites as part of the incidental power.
Therefore, you can prescribe the pre. That's how I understand it.
Yes, as part of the incidental power. And there are case law on incidental and ancillary power under the rules of construction. We have cited it, and some English cases which have reiterated it. Other, you don't readily infer ultra vires. You start with a presumption even in subordinate legislation that it is intra vires.
Any legislation, you will try to see that it is sustained as long as it is sustainable.
In substantive law, your Lordship will say constitutionality. Here, my lord, it's intra vires. There, my lord, your Lordship will grant all the power because everything cannot be specified. So, you grant the power and that will encompass, it will envelop within itself such of those accidental, ancillary to further the objects of the Act. It's not something alien to the Act. We are only trying to improve the standard. Who is entitled to enroll, and they say you now take this exam. That cannot be, and Mr. Rao, who appeared for the Bar Council, canvass this 49. Your Lordship will see from Sudhir. Not that, my lord, this is all what we are doing. Rao had canvassed it, my lord, in 1999, Sudhir was arguing. Fourthly, it is submitted that while assuming that the Amendment Act of 1973 did take away the express power vested in the Act for holding of pre-enrollment training, it would still not take away the overarching rule-making power that is vested with the Bar Council of India in this regard. Context may be given to the introduction of an examination and the very act of repeal of the same. In the All India Bar Committee of 1953, it was recommended that the uniform minimum qualification for admission to the role of advocate should be a law degree of at least 2 years of study, at least, of law, followed by 1 year apprentice course in practical subjects, followed by examination in these subjects. We have put the Attorney General's compilation below. The Attorney General was gracious enough to make his compilation available yesterday to us. The functions recommended for the State Bar Councils by the committee also read as follows. Power to provide and make arrangements for imparting legal education, holding examination and training of advocates under the directions of All India Bar Council. There is a very interesting passage in the early pages of the note. I just digress a bit and go there for this reason. Page 6. Page 5, your Lordship sees. Something, my lord, which is a practical insight to this. Keep, your Lordship may continue with 26, but just digress and go to page 5 of the note.
Yes.
While the Advocates Act of 1961 was yet to be tabled in the Parliament, the Law Commission of India in the 14th report on reform of judicial administration sought to endorse the views of the All India Bar Committee and further provided insight into the considerations that led to the need for a central legislation for advocates. Committee noted that every student of law must, after a 2-year study in university, have a practical course in law to be imparted by the Bar Council. Thereafter, in the context of law examination to be conducted at the end of the practical course, the report stated the following, which is of significance even today. We have already recommended, that is at the Attorney General's compilation, page 107 at 110. We have already recommended the division of legal training into 2 years training in the principles and theory of law to be imparted in full-time institutions and a year's practical training to be imparted under the direction of a body of professional men. At the end of the university training of 2 years, the law graduate will have to decide whether he wishes to embark on an academic career to research in law or a professional career through a practical training in law. A practical training is as essential to the making of a professional lawyer as through academic training, as a thorough academic training. The matter has to be picturesquely put in the following words by a writer. All the theory in the world ill equips the lawyer who has all the legal lore at his fingertips, but doesn't know how to draw a summons, a will, a deed, or a bill of sale. Law schools furnish their graduates with new, shiny, potent tools. Unfortunately, the average graduate has as little knowledge of how to use them as a 2-year-old child has of how to use a blowtorch. Perhaps Chief Justice Vanderbilt had graduates of this kind in mind when he observed that law school should be concerned not only with the principles of law, but with the know-how of putting the principles to work. Law schools of the country cannot continue to lag behind the engineering and scientific schools with their laboratory work or the medical colleges with their clinics. It is not right that young lawyers should learn the skills required in the profession at the expense of their clinics. I'm sure Mr. Mishra will work out an arrangement for the training without prejudicing the trainees and allowing them to fend for themselves.
Earlier, it used to be a 2 years law course with proficiency. It's called proficiency itself. 1 year proficiency, 2 years law course.
And your lordship is right. In the early 60s, I understand, Lord, you have to pay to join a leading firm of solicitors. Pay the other.
That dynamics has completely changed. Dynamics, as Mr. Gopal said, that it's not the course of last refuge. For many, it's the course of the first option.
First choice. And there are law colleges have day zero, where the placement happens, and then they are picked up. All the national law schools have more than 60, 70 students in every batch being picked up. Got by corporate and in the litigation of big law firms. 53, page 26. Kindly come back to 26. Because we are still analyzing the scheme of the Act. Thereafter, the 14th report of the Law Commission of India on reform of judicial administration, Commission specifically approved a 2-year study at a university followed by a practical course in the law, which will then be followed by an examination. The specific context requiring an examination and training as a power specifically vested with the State Bar Council is that university education was to be for 2 years, followed by a specific 1-year training and examination to further equip a graduate with the skills required to be an advocate. This can be read to be part of the intention to have a thorough legal education for candidates, given the yearly structure that was proposed for the candidates. It is therefore in this background and context that the State Bar Councils were vested with the power to prescribe pre-enrollment training and examination. Submitted that in this light, the repeal in the year 1973 is also to be considered. Requirement for a 1-year training and examination in order to equip a graduate with the skills while he was still part of the education system was found to be necessary due to the 3-year law course introduction as a consequence of the power of the State Bar Council. Then, having considered the context in which the above mentioned examination was to be conducted, humbly submitted that this examination was specifically brought into the Act to be part of the legal education curriculum of a candidate, having found to be unnecessary based on its linkage to the duration of the course, would not in any manner restrict the overarching power of the Bar Council under 49(1)(a)(g), which empowers the prescription of a condition that would entitle. The lordship can skip because that point is made. 55(24) capital A is misplaced, because that is power to disqualify a person from enrollment. Is materially different from prescribing condition, This is Majumdar, adverts to this clause to say that it is not even part of 24A that a person who has not taken the exam would be disqualified. Then, on incidental and ancillary power, kindly come to para 57. There can be no quarrel with the proposition emerging from the judgment in Sudhir in view of the opening words of 49(1) reads, Bar Council of India may make such rules for discharging functions under this Act. Your lordships have always held that the opening words in a rulemaking clause have its own potency and power as long as it is for discharge of function. And the enumeration is only illustrative. Kindly see 49(1). 49(1). When you say in particular or including the following, the opening words are all encompassing. As long as the rule is enacted for furthering the object of the Act. The Bar Council of India may make rules for discharging its functions under this Act.
Just one. Bar Council of India may make rules for discharging its functions. The power of enrollment is not with the Bar Council of India.
Power,
Power of enrollment is with the state bar councils.
to fix the criteria.
Correct. That is something different.
Yes.
But power of enrollment,
That is true. The formal enrollment is not.
the power to enroll is with the state bar councils. And that may be the reason why they had said initially that the power of training and examination will be with the state bar council. Now, in that light, now read the powers.
Now, Miller. In particular, such rules may prescribe. Kindly come to A, G, Miller. Shall I place the entire scheme?
No, that's fine.
The class or category of person entitled to be enrolled as well. That is Miller. So, while it is true
We
that
have to give the only way to accept your submission is to give an expanded notion to AG. When we give the class or category of persons entitled to be enrolled as advocate,
there is a legal principle why
please correct me if I'm rephrasing what you are saying. That this expression class or category of persons would include the class and category of persons who have cleared the pre-bar exam. This is what I.
And there is a legitimate legal jurisprudential basis which comes to the next point.
Just one more thing. You see, ultimately, if we hold that your right to practice depends upon your clearing the bar exam, whether it's pre-enrollment or post-pre-enrollment, ultimately functions and performs the same
Except that post-enrollment, that 30 comes in the way. I have dealt with it.
that we'll examine.
But pre-enrollment will not, subject to what your lordship says.
Your submission is the correct and simplest method is to provide a pre-enrollment examination to obviate all these possibilities. And therefore, if the expression is shared in 49 are taken to include while enrollment, then that would subserve the purpose.
And how do we, Milord, invoke any principle to include that? Milord, kindly see the Kargar Panchayat. I'll read page 28, paragraph 58, and then Milord come to this doctrine of incidental and ancillary powers. A well-known, Milord, rule of construction in administrative law. However, page 28, paragraph 58, in applying this principle to the Advocates Act, this Honorable Court failed to consider the BCA training rules could be traced to the BCA's function of exercising general supervision and control over state bar councils under clause G of 7.1 of the Act. There is also this power that 7.1, when it deals with the functions of the Bar Council of India, it says supervision and control. 6 deals with functions of the Bar Council of the state. Functions of Bar Council of India. 7.1G shall be to exercise general supervision and control over state bar council. I am not suggesting to my lord that we have to do an overall reading of the Act. If the object of the Act, see the specific provisions, then my lord see whether and category give a legitimate basis for construing that the Bar Council of India can prescribe an All India Bar exam. But kindly come back to 28, Milord. Line about 3, 4. Secondly, this Honorable Court erred in interpreting 7 of the Act as a provision which exhaustively lists the BCA's statutory functions. Why do I say so? Because 7, Milord, before your lordship do away with 7. Kindly see, Milord, there. H. This 6, 7. Yeah. L, Milord. 7L also. To perform all other functions conferred on it by or under the Act. do all other things necessary for discharging, to perform all other functions conferred on it by or under this act. By the act is, your lordship knows, by the provisions themselves, or under the act, your lord will also include the rule making, will not power. Kindly come back to 28, you know. Thirdly, it is submitted that an additional
AG में लिया रहे हैं ना बार बार कैटेगरी ऑफ
this kind of scenario.
Mr. Anand, we have a special bench at 4:45.
Resume tomorrow.
Continue tomorrow.
Wait for
Comparisons are the engineer, कल पार्टनर item
वो जो रिजेक्ट वाला है ना कल
142 काटे मुझे लगा
अली मानव जी को कल सुना जाएगा देखा लेकिन मैं
कोई ना एप्लीकेशन डालने को इंक्रीडिबल
टीपी में एप्लीकेशन मैंने कि हाँ 142 की पावर एक्सरसाइज करना वो पोस्ट करना 142
It should be
Why should you
press on पचास लगा देते हैं
सुनाओ 2 मिनट सुन लेंगे उनको वैसे ही
who is appearing in this application?
you might be making a mention tomorrow
He mentioned it. When he mentioned we'll deal with it.
May I just ask that your lordship should submit the written submissions in advance or during the course of the hearing, whenever lordship's turn comes tomorrow after.
You are, I take it, are you opposing
What your lordships, the amicus here is suggesting, we're opposing the bar exam which is in current existence. We're not opposing a pre-enrollment bar
So
exam.
you're okay with pre-enrollment?
Yes, your lordship.
That's fine.
Yes, your lordship. We are all done.
Actually, I think everybody is saying pre-enrollment. Is there
Yes,
somebody
yes.
opposing even pre-enrollment? I want to know.
the only
no,
only thing is whether the V Sudhir will not, because V Sudhir is directly on this point.
We are considering,
yes,
that's why the opposition bench is considering this. So therefore, we take it that everybody is advised that pre-enrollment exam should take
Yes,
place,
yes.
which can only happen if we modulate Sudhir.
Yes,
That's all that is there.
Lordship, just certain points with regard to the pre-enrollment examination.
And now,
Modality.
you point out if we want to listen to you on something.
Yeah.
If you are supporting pre-enrollment exam, there is no point in duplication of argument.
Is your stand something contrary to what has been argued till now? Say
Lordship,
yes or no, for you to decide, not for us to decide.
lordship partly.
Okay.
Partly.
Then you will have to see what that partly is for us. to- Thank you.
The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that the claim is made to have a split in the original political party. In addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the split in the original political party, cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, Mother, what's important here, Mother, and this is the significant part. Having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the Speaker and the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the Speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. There are 31 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to it. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. If it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. What will happen on the 19th of July thereafter has nothing to do with what's happened before, because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. But the CRA, volume 2. First, we show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Cindy on the 30th of June. It is much before 19th July. At page 321. Convenience compilation. volume 2, page 321.
Yes.
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of power vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, I tell him that you have already by wax given up membership of the party. So it's not a question, of removing him from the post. Now see the letter we write to the commission. Page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. The now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was the nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Mullahs, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. How is that possible to say that no, these are two different cycles? Now, and therefore, I'm saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Mothers, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where a original political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Mothers, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. He merges with another party, or he has another party merge with him and he forms a new party. The new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off from Shiv Sena. That's the consequence of paragraph 4. And he can't maintain a petition under paragraph 15. Because he's either merged or he's formed a new political party. And those who are left behind, that is, who are less than one third, because 2/3 makes others, those belong to the original political. This case, Mother, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that over the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Zibal, you can conclude your argument.
No, you are in rejoinder council.
They have argued for this.
No, that cannot be tit. No, that cannot be tit for tat that he has taken 2 hours.
Cited certain fragments for which
All right, Mr. Zibal, you can deal with the judgments. You can tell us what the point of distinction, what we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it. Now, therefore, now let's come to paragraph D. I'm only saying
Paragraph D of
okay. Our Mr. My colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground.
yes, the grounds.
What your prayers?
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that there are 2 other judgments. It's all right. The whole paragraph.
No,
Let's read the whole paragraph.
Ground D of ground page 8, right?
Because children.
Ani, so further email it does. Affidavit or so. Now kindly come to E. Eknath Shinde on 19/7/22 filed a petition before the commission titled that so and so on the para 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, I mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to para 3 at page 47. Now, this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para.
That's the point, Mother.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, Mother. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that is something to do with the other. And I'm not saying, I'm only saying, Miller, he says these are great repercussions. Because in this situation, then X number of people of a political party who are in power can be named away. Governor will give them votes. And we'll go to the election commission and say, you declare us the simple Millers. And that's a consequence, which is sought to be prevented by taking away the third paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is just not having space. And paragraph 36 minutes. Also read it half of it. I'll just read that minutes. Page 10 minutes. The contents of paragraph 24 to 32 are denied. It is submitted that clearly claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of Whip 37 as well as of 47, and having read the writing on the wall as to their imminent disqualification from membership of the Assembly, the splinter group has now rushed to the Election Commission to claim that they are the real Shiv Sena. This is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. My learned friend cited two other judgments. The Kerala judgment where there was no disqualification.
2021 4 23, he said at page 50.
Well, then,
but he didn't read it out.
Let's see, Palani Swami, what does he cite?
Palani Swami.
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to? Or should it be frozen? Interim symbol, which has nothing to do with the tension. Palani Swami had nothing to do with the tension. The matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment, my learned friend cited, the Kerala judgment. So that my colleague.
That Mr.
Jetmalani cited.
He didn't cite.
Paragraph 4, Mother.
He really just gave us a citation.
He has no doubt.
No, he said that this is the first time the court has decided.
Page 51.
Yes, now, Mother, I just note paragraph 6 of that judgment says, the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 mothers. Para 6.
At page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiyalal Umar. Now, Kanhaiyalal Umar, mother, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. As well as all party Hills Leaders Conference, brother. That was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let us kindly see what the notice of the commission is to us. Page 701. Compilation Miller's document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
That is document number 9.
Yeah, on due consideration of the totality of information available on record to the Commission, as summarized above, the Commission is of the opinion that there are two rival groups in Shiv Sena party. So he's already assumed that there are rival groups in Shiv Sena when the whole question is whether he's a part of Shiv Sena or not. One led by Uddhav Thackeray and the other led by Eknath Shinde. So you assume this, Madhur, on what basis do you assume this? And each group is now claiming the party. It's not my thing. I am saying he's no longer in the party, he's voluntarily given up. On what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say not even keel? And to protect their rights and interests and going by the past precedent, commission has directed that the documents submitted by the rival group be exchanged and replied. Even then, then was interesting. The steps envisaged under para 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. Mothers, they are aware of my letter, mothers, at paragraph 2, mothers, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, commission can't decide that issue. So now let's go back to the last part at 702 that I was reading. Support claimed by them in organizational and legislative ways. Well, let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogable is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment said that has to be considered. So if the legislative wing, according to us, all 40 of them, are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shiv Sena when they are voluntarily resigned. I have informed you about it. And you say we will treat it as an even keel. Nobody disputes whether a big argument is made about 324. Nobody disputes that power. Who disputes the plenary power of the election commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the election commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first to be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the election commission on the 19th of July and say, I am the party mother. Certainly the election commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of defection. And what used to happen? The history of litigation in this area would have shown that every faction used to throw out membership members of the other faction. And obviously, election commission could not decide those issues. So they say, okay, let both factions come and we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we have 2-1 at all? It is only a question of the legislature. Argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the election commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordship decided in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? And turn the clock back. Election commission has decided. So it makes my petition infectious. If our lordship decide against me and say no, what happened was perfectly legal, in any case they will get the symbol. So they are not in any case prejudiced. Why is it that we want this to go on today? When your lordship can decide this matter in October, here the matter decided. What is the great urgency today that this must go before the election commission so that the other freezes the symbol or gives it to somebody without having this matter decided? And then they say, look, my speaker is there, my speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. Same one has glossed over. So how will the speaker decide that issue? And then the larger question is whether when they go to the deputy speaker that you are disqualified because we have moved a notice of removal against you, mother. The speaker said this hasn't come from any source at all. It has come from an email that I am not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And mothers, what's interesting is this court, and I'm sorry, mothers, I'm taking time, I didn't want to take too much time to watch it. Well, let's see what the order of the court is on the 27th. Then show me careful. It says, meanwhile, as in the 10 months, sorry. Yeah.
So what is the date of the order?
Date is 27th of June.
PF 2151.
2151.
Compilation of orders and pleadings is there in page C, Madhus.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yeah,
page 3.
meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Malad? Now see the Holo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended it. Now let's see the order. See Kyoto. Para 110. Order is in the teeth of 5, the constitutional bench of this court. Then the government was offered. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I'll read it. No need for Kyoto. In view of the limited scope of judicial review, it is available in para 6. And also having regard to the constitutional intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review, prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible or would be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceeding. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interact the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. Where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, we said, in fact, I remember I had told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It makes no difference. Inner party democracy is in the context you are continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it, and this is inner party democracy that's been given up. This concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide. But in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. That's it.
Thank you, Mr. Yes, Mr. Yes, Dr.
I'll give it in point form. What is the crux of the case? Or the nature of the phrase voluntarily giving up membership of the party. There is, in actual practice, 90 if not 95% of acts or omissions coming under 21A relate to activities outside the house by the very nature. examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust board, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to only 5 minutes. Ravi Nayak. Before I cited the book out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. Well, it's been given to your lordships. Kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read first that middle practice. Middle of para 11, my lord. The said paragraph provides for disqualification of a member, they are talking of a house belonging to a political party, if he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordship's fellas has to consider, and not your lordship's fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. An inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And that is what is happening. Point number 2 is, your lordship may kindly read again to save time, I will not read it, the 4th of August 22 order of this honorable court. The last 4 lines, and we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this: according to the learned senior counsel, that is Mr. Tata, it says so. The proceedings will take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is whether the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This is point number 4. This ground of IA. lordships, because I don't think should be catered by the form of an IA versus the substance of what we want. That's the simpler answer. But two more important answers for us in law. It would be, according to me, quite quaint if your lordship said that because an IA, the lordship can't decide this matter, it's outside the scope of the main matter. But there are two other answers, factually wrong. Number one, we find several writs, including what your lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior, commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this election commission is initiated. I filed an IA saying that this is a subsequent development. Why your lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your lordship fellows cannot touch it? Therefore, that is, well, I hope, not their best argument. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Kaur read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Kaur read the sentence to be very
para 27 and 48. There's just one more. Let me go to grammar.
27 is the answer to 25. So that the context is placed in 27, which was has to be read.
Just give us, just give a moment. Page 192, right?
Yes. So my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para classical C. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim, mark the word independent, of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Kaur read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the Speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the Speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal while considering a claim for disqualification of a member or members to decide that also in the context of 3 raised by those who are that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the Speaker, who is a persona designata by the Constitution, no less. Now, while your worship is on this, just let me finish on 48 of the same judgment. Also, not this great. This is just 2 lines. This is just to correct, as one out of hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involves a very specific case. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership to the party or to restrict the said members and party. It is all over the press and repeated that they went on this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in Paramatma. My fifth point is that your lordship is cited first. I want to make a general fifth point and then tell you. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded by submission. It's a rather broad thing, I don't want to make a case. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is that Omar, etc. 1985, 4 SCC 628. Just note the citation I have not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules? That's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. Well, it's, may I end by saying, after thanking a lot for giving us time, that if the party, if there is, why, should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also, I'm not saying, but I'm saying that that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be briefly decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes the speaker is disqualified. Then the persona designata, then you start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps will interview. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 2(1)(a), which the speaker to his best ability decides. Today, in effect, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided in this?
Decide it first is what your lordship is told. I will let the EC decide it first. B, as the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will decide by the state.
That's just one submission for your lordship's kind consideration. Only on Kihoto Holo.
No, it cannot be Mr.
Then that was Kihoto Holo. Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. Kihoto Holo said that while a show cause notice by a speaker is issued,
no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and then the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibal presumes that we are disqualified and the EC today cannot be approached.
All right.
First issue.
Yes. Heard Mr. Sibal and Dr. Abhishek Singhi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Mr. Tushar Mehta, then Solicitor General, has appeared on behalf of the Governor. Mr. Arun Detta, then Senior Counsel, has appeared on behalf of the Election Commission. Next. We've heard the. Sorry? Oh, yes, Mr. K.
What's it forgot me?
I'm so sorry.
No. Quite forget me.
No, that's all.
Apologies. Having heard the Learning Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.
Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. So there is no concept of potential or deemed disqualification. It has to be actual, however, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which had never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the deputy speaker, in this case, there was no speaker because the then speaker had resigned since 5th February 2021. But the deputy speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House for his position as deputy speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as deputy speaker, i.e., the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it, but it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the speaker of the deputy speakers, a majority is itself question, he must desist from the adjudication process. So it's not just Navam Varia, which is one of the questions of law propounded. Navam Varia does say so. And we're having a second look at it, but also Article 181. Remember, two more propositions. Yes. Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner is determinative of this matter. That's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned, 29th 29 July. June. Sorry, June. 29 June. I'm so sorry. 29 June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the chief minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the house, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us lots of the citation. Rameshwar Prasad. Number one, in that judgment, the court said, when the governor is setting about the task, and it's paragraph 161 in particular, what's it just now? When he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Rameshwar Prasad.
Yes. 2006 to SEC page 1. The legislative assembly of a state shall, as soon as they be, choose 2 members of the assembly to be respectively speaker and deputy speaker thereof, and so often as the office of speaker or deputy speaker becomes vacant, the assembly shall choose another member. Now, on the new government being formed, an election was held for a new speaker. This was the mandate of 178. A new speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new speaker. Any questions of disqualification, and my lord, the deputy speaker only performs the task of the speaker when the speaker is not there. Once you have a speaker, any question of disqualification now goes to the speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new speaker has come. So, in short, my lord, I hope that. Thank you. Mr. Datar. But just one question of Justice. But there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10 schedule and the election commission. It's a division bench of the Kerala High Court.
What is the citation?
Yes. Okay. It's in the compilation. It's 2021 4 KLT SN 33, page 51. But it's in our compilation and it's judgment number 7 in our compilation of that. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned. Okay. And the impact of each.
Mr. Solicitor, you want to?
Sir, only 5 minutes because I appear for the governor. Therefore, my role is different. In my role, I have already played, and if required, I may play. But only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background, and 5 minutes is broadly outer. When 324 was framed, so there is a beautiful discussion which I will not read, I pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of president rule, etc., in a different fact situation which is not arising. The only question which needs answer
for the today's limited hearing is, can your lordships not take a call whether this faction is right or another faction is right? That answer, my lord, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, two factions claim that I am the original party. Somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Kaul and Maninder Singh, would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party. Would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordships are assisted on both spheres.
Yes.
Here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech and expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party because there is no disqualification from membership. So the Election Commission is merely deciding which group represents the original one. So, right now, for the limited purpose, my respectful submission is that let the Election Commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta?
My submission is earlier that the functioning of the Election Commission is completely different and independent from the role of the Speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. We'll have to first go through that. Lordship just takes 10th schedule. This Articles 102.2 and 191.2.
Yes.
And Lord, since we are referring to a state assembly, I will confine myself to Article 191. So, Lordship, Lord, I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note that along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 102.2 and 191.2. And if your Lordship sees 191.2, a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Now, please come to 191.1a. Your Lordship kindly sees, person shall be disqualified from being chosen and for being a member. So, my Lord, there are two types of disqualifications. A threshold disqualification, where you can't even become a member.
And during the
second, during. But in the company law, they use more elegantly. They say disqualification and vacation. You become a director, then you vacate the office. So, when we say disqualification for being, it actually means disqualification from continuing as a member of the House. Now, Lordship will just see A, if he holds any office of profit, B, if he's of unsound mind, C, if he's an undischarged insolvent, and D, if he is not a citizen of India and has voluntarily acquired citizenships, etc. And E, if he is so disqualified under any law by or any law made by Parliament. The Lordship will find that there are 4 constitutional disqualifications, which is A, B, C, D. the fifth constitutional disqualification is 192 to 191(2). And if your lordship sees what is 191(1)(e), if he is so disqualified or under any law made by Parliament, lordship has to look at the Representation of People Act 1951. But I will be basically referring to the Constitution and the Representation of People Act. So lordship will just keep these bare acts. Now, if lordship just sees the index, the table of contents of the Act, of the Representation of People Act 1951. The Lord will find that as far as the Representation of People Act is concerned, we see the table of contents, the index will give you also the architecture of the Act. Chapter 1 and 2 talk of qualifications. And my lord will kindly notice that chapter 3 and 4 deal with disqualification. It's a very small act.
I just, in an order yesterday, we said 50. I just told him I had a recollection that I did
Yes.
50.
In fact, the statement of office and reasons say that 50 Act is very short, so we have to expand it further.
Yes.
So, lordship will kindly come to chapter 3, just the headings. Definition, disqualification for conviction, disqualification ground of corrupt practice, disqualification, etc., etc. And chapter 4 is disqualification for voting, where you are a member but you can't vote. What I'm submitting is the Parliament and the Constitution has consistently made the difference between what are disqualification under the Constitution and what are disqualification. As the Representative People Act is concerned, the authority to decide is the Election Commission. Actually, I come to 191. The President will decide, but he will take the opinion of the Election Commission. If your lordship now, so the point I'm making is the disqualification given in the Representation of People Act 1951 is a completely different thing. The role of the Election Commission, the constitutional body, is clearly demarcated, and it is neither hedged nor restricted by the 10th schedule in any manner. Lordship now comes back to 191, the next section 192, Article 192.
Yes.
If any question arises, 192, and Lord, this is equal to 103. Lord, just makes a note. Parallel provision Parliament is 113. If any question arises as to whether a member of a house of a legislature of a state has become subject to the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the governor and his decision shall be final. 2. If before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. So, disqualifications in clause 1, constitutional disqualifications plus under the Act, these are decided by the governor, but he will take the opinion of the Election Commission. Now, yeah, and lordship will kindly note the governor shall obtain the opinion of the Election Commission. So he has to. So the Act very clearly demarcates the role of the Election Commission as quite distinct, separate, and the parameters are prescribed. Now let's go to the 10th schedule. Will first see para 2C is original political party. Original political party. But if my lord sees the definition in the Representation of People Act 2F, my learned friend, I think somebody referred to the room, but if your lordship goes to the Act itself, the Representation of People Act under 2F,
Political party.
Political party means a political party which is, once again, this opens into the 50 Act.
Mr. Maninder Singh referred to that.
He referred to
To the rule. Identical.
identical.
Symbol order.
Yes, I think in the symbol order it's 2H and here it is 2F. But the point I'm making is the purpose.
2H.
Yeah, 2H in the rules, 2F in the.
2F corresponds